Hi all. I'm just running this as a bit of a background to the semester test for CO5119 Business Law in 2020. I've had a few students that have sort of asked that I sort of get the ball rolling in terms of giving you some more information about the content of the test. And this is really to sort of um, allay some fears and give you guys a bit of confidence about this test and what's going to be required throughout it. As you know, the test is actually be held on Friday in week 6, and it's covering the first 6 weeks worth of content. So that's the first 2 weeks, the two introductory weeks, one on the introduction to law, and the second on the Australian specific context, the Australian legal system, and in particular our court structure and the mechanisms for alternative dispute resolution. But we're also doing the first 4 out of 5 weeks of contract law as well. And of note, the final week, the fourth week of contract, which is discharge, where we talk about how contracts come to an end, and we look at remedies. That stuff is the lecture for that week, but it's also assessed in the test that week as well. So you've got to be really conscious of that. And I would recommend that week too to actually go through just a little bit in advance and really do a bit of prior reading before going to the lecture, and really use that particular lecture to help you solidify things. So you want to be a little bit ahead of the game for that one. There's screencasts that are available, so pre-recordings that I've done over the last 2 years for this subject on the channel. Now, the test itself is 20 questions. It's multi-choice, so you're going to get each question comes from a pool. There's 17 different pools, so there's some pools you'll be asked 2 questions. Most pools you'll just be asked 1 question from that, and it'll be randomized. So you'll get given, again, for most of the questions you'll have just 1 question from a pool of between sort of 6 to 10 different questions. They're all of the same level of difficulty. It's multi-choice, and with most of the questions, you'll have usually 4 or 5 possible answers to choose from. The format of a lot of the questions, rather than just being here's a statement, choose an answer, usually what it is that there'll be a series of statements, and you'll have to determine which ones are sort of correct about a particular legal rule principle, which ones are incorrect. And so where the answers are structured will be, to say, for example, there are, say, 4 statements, or maybe 5 statements of rules or descriptions of a particular rule, and the answer will say something like, well, A, B, and C are correct, D and E are incorrect, or A and B are correct, C, D, and E are incorrect, or none of them are correct, or all of them are correct, or A and E are correct, B, C, and D are incorrect. It's that style of question and answering that you'll be expected to do as part of this particular test. There are, towards the end of the test, there are 3 questions that are a little bit harder. So the question will be asked for something a little bit more focused, require you to have a little bit more thought, and you'll tell it's the slightly harder ones because they'll have more than 4 or 5 options. They sort of have 7, some of them, I think most of them have 8 different options to choose from. So just be a bit sort of cognizant of that, and in particular that the time that you might want to spend on those, you appreciate, is probably going to be slightly longer. And just note that the test itself is 45 minutes for 20 questions. You've got to do it on your own, and in fact, it's going to use the responder system. Now, for those that haven't used the responder system or something similar to it in other institutions or at JCU, it's basically an anti-cheating measure to ensure the integrity of the testing, that requires you to have a webcam, and it requires you to use a custom browser as part of the process. So when you go in to do the test, there'll be a period where they'll get you to just to test your browser, test your computer, test your webcam. And when the test is ready to go, that usually takes about 10 minutes. When that's ready to go, then it'll get you to basically sort of get the webcam and show it around the room just to demonstrate that no one else is there sitting behind you, just feeding you the answers. You'll also have to hold up your notes as well. For this test, you are allowed books other than library books. Can't use library books, although you can photocopy them if need be. Any of your own notes, either handwritten or typed. Any of the lecture slides as well. And so I recommended to classes in previous years that you feel free to print the lecture slides out. I can deliver them in docx format, so without the need to have all sorts of pictures on them if that's required. And I also recommend that you actually annotate them. Go and take the lecture slides, print them out, and annotate them. And a lot of people have been doing that in class. I think that's wise to go through and to do that. Now, in terms of the content of the test, I made the point that there are 20 questions. They're drawn from 17 different pools, which are on the screen at the moment. So the first 2 questions, which is drawn from the same pools, is about the stuff in the first 2 weeks. It's general stuff about what is law, and what is the Australian legal system, how the doctrine of precedent works, how Australian courts work, how the history of the Australian legal system in terms of the dates where things came into existence, and so that's the general stuff that we had from the first 2 weeks. It's since this is something of a little bit of a general knowledge question and answer, rather than being a specific technical series of questions. The third question you'll get, though, is specifically about alternative dispute resolution. And so you really need to answer that question. You need to know what ADR is, but you also need to know what each of the types are. The difference between mediation, conciliation, arbitration, case appraisal, or case or expert appraisal, and this idea in particular of things starting from very informal, so direct negotiation between the parties, all the way up through to the very, very formal of arbitration. So that's something you need to go through and examine to answer that question. The next question is on contract formation generally. So how do contracts get formed? This is to do really with offer and acceptance as the main one. There'll be a little bit, you might get a question on intention correct legal relations, but you're more likely there to get offer and acceptance, to know what an offer is, to know what acceptance of offers is, to know some of the rules and exceptions to that, the postal acceptance rule, and the rules for counter offers and cross offers. It should be across all of those terms, and really be able to describe them in a sentence or two to really be able to answer that cleanly. The next question you'll get will be either on legality or mutuality or contracting with minors. So you get one question from that pool which has those 3 areas. There's not really much to say about legality. That will, again, the idea of that it's an element of a contract, but it's also a vitiating factor, which we'll talk about in a few weeks' time. And sort of also be cognizant here that while I'm going through these areas of law for you guys, particularly those that need to start studying now, some of the content you're not going to be exposed to yet. So some of the concepts are going to are still a few weeks away in terms of lectures. But yeah, that idea of contracting with minors, there's a few questions there in the pool about that, about what sort of things you can and can't do. Okay, the next question is on the doctrine of consideration. And we have gone through that in lectures at this, and really it's the consideration and also a thing called the doctrine of privity, which relates to that, the idea that people who aren't party to a contract can't sue or be sued on it. Why? Because they didn't offer consideration. And so that these 2 doctrines sit kind of uncomfortably together is an area of law. But consideration is just the idea of the physical things, the promises that both parties need to do. They either need to give each other something or promise to do something, some sort of detriment to themselves. The next 2 questions are from a pool of questions that are about terms, and what terms are, what are the difference between different types of terms, different classifications of terms, how terms are different from other forms of representation, so sort of a mere representation with no legal effect, or a legal puff, or a collateral contract, or a misrepresentation. You need to know the difference between representations and know how to classify those into the various areas, those that have legal effect and those that don't. So again, we'll spend all of this week on terms, and the other rules there too. The rules to do with exclusion clauses we'll talk about as well, and onerous terms as well. Then we're going to look about vitiating factors generally. There's one sort of general question on vitiating factors. So this could be from any of them: misrepresentation, mistake, duress, unconscionable transactions, undue influence, and illegality. And so that this area of contract law where on the face of it there's a valid contract but there's some form of defect in it. So this vitiating factors question is going to be general. It's going to generally ask you to examine a particular concept and answer on that. Then there's going to be particular questions on three areas of vitiating factors: misrepresentation, mistake, and duress. And so you're going to have to know what each of those areas are and what the rules for them are, and how sort of courts determine them, and what happens if those things are if one side manages to prove that those particular causes of action. What sort of results going to happen? The next question will be on generally on the idea of discharge, how contracts get discharged. So you're going to have to know the rules of performance, exact performance, the doctrine of substantial performance, the de minimis rule. You'll have to know this idea of divisible obligations, and really this all flows from this idea that the courts want to uphold contractual obligations. They want people to do what they say they're going to do, and so that they don't lightly infer that that a contract is somehow like come to an end. They want people to be able to do what they say they're going to do, but also resolve their difficulties without having to go to court as well. After that, we're going to talk about one specific type, or it could be you'll have a question on one specific type, which is the frustration. Frustration is to do with an event that comes outside of any of the parties' contemplation that completely destroys the subject matter. In fact, coronavirus will almost certainly be a topic of conversation when we reach that particular part in the lecture series. After that, we're going to look at you'll get a question on remedies, which is what's assuming that a contract is coming to an end, if through breach, what happens next? What is what's the result, and what do the parties get? Usually the default remedy is damages or a dollar award, but there are some other sort of narrower and rarer things that you can get granted by a court. And so those 15 questions are very much the formative. They'll have between 4 and 5 possible answers, and it's really going to really check that you know particular contract concepts, and can be able to look at a series of statements and determine which are true and false about each of those particular rules. Now the next 2 questions are a longer one. They're actually going to be a scenario, so you're going to have to read. So just be a little bit mindful that while the test is 45 minutes and there's 20 questions, which in theory you would want to set aside sort of just over 2 minutes for each one. It's in practice these longer scenarios are going to take a little bit longer to read, particularly those for English as a second or a third language. It's going to be it's going to require you to read a scenario, really try and work out which legal principles are the appropriate ones there. When I say longer, I mean most of them will be sort of five or six sentences, so they're not going to be full half-page narratives, but you will have to go through, and really in those situations you're going to have to know what it is, which legal rule or principle are we really going to be able to use to usually get a result, and so that you need to be keeping on your feet and really thinking about what particularly for the vitiating factors, which ones are most likely to apply, and with contractual breach, what the result is going to be when the other side doesn't do what they say they're going to do. So you're going to have to know those, and you're going to probably have to spend a little bit more than 2 minutes on them. Okay, the final three questions are specifically for this subject, which kind of differentiates it from the undergrad offerings. This test is a little bit harder because you'll have a slightly more precise question on the Australian legal system, basically the material from the first 2 weeks, one on alternative dispute resolution, and one on contract law across each of the topics. So there you go. Those questions are they flow from the in-class discussion that we've been having in regards to those the handouts we have in class, and they're a little bit harder because they require you to think a little bit more. You're going to have to take some of the material that's presented to you and just delve a little bit more into that. The other thing to note about those is that there's more possible answers. So look, it's harder to guess because there'll be, rather than being sort of 4 or 5 possible answers, there'll be I think it's between 8 and 10. So just be a little cognizant of that. There's no, particularly for the contract one, there's nothing in particular to concentrate on, but you will have to be across all of the material in order to be able to really sort of join the dots between areas to describe, why is this particular feature. So for example, why is undue influence different from and yet somehow similar to duress in common law? Things like that, where you have to think about each of those two sets of legal rules and principles and think about how and why they are similar and why they are different, which can be a little bit challenging. But the one in ADR is essentially similar to the earlier ADR question, but it's going to be, again, require you to sort of think about it a little bit more when comparing and contrasting the different things, the different areas of ADR with each other. Okay, so to do well in this test, you have to have a good knowledge of the rules themselves. And really, when learning a subject like law, the best way to do it is when you're learning a new rule or principle, relate it back to your life, relate it back to things that you've done, and try to get a handle on the language component of it. When you've had contractual arrangements with people, think about what an offer is, think about what acceptance of that offer is, think about intention to create legal relations, capacity, consideration, and so on. Think about the terms of the contract as a series of promises. Think about times where people have had contracts and tried to use exclusion clauses. It's really be able to relate that to your personal and professional lives. It's going to be the really helpful thing to do. I find with these things, if you're going to do things like flashcards, to be able to explain each rule or principle in a sentence or two is probably the way to go for the vast majority of this test. Other than the final few questions where you have to think on your feet a bit and really take a variety of different rules and principles and see the connections between those. Generally it's going to be have a quick knowledge of the thing, and because it's open book, even the ability to go to your own notes and find where you've defined or described something to yourself can be a very helpful thing. It's open book and that you can take your notes with you, but it's be mindful of that as a crutch. Be very, very, very mindful that open book exams, yes, they are a little different, and that you've got more chance and scope to prepare. So I suggest you guys do go through and do that, and I think you'll be fine in regards to that. So I'm going to leave the stream there. I hope this was useful. It was a little bit longer than I was expecting, and I'm looking forward to seeing both the externals this week and the internals in class. Thanks, team.